hearing about, give you some things to be thinking about. As Jeff mentioned, my name is Heidi Seaton. I'm VP of Legal and Compliance here at Orange Tree. I've been in background screening now about 21 years, I think. As you may notice by the title of the webinar, we try to get online and talk to customers and other prospective customers and other people out in the world about background screening about once a quarter. So you'll notice that this is in the format of an update. But we do sort of tend to see similar topics coming up over and over. And so we sort of group them here. We're going to talk about Ban the Box and some fair chance and decriminalization efforts that are happening. We'll give some updates. So last time we talked in March, we had a few things that were sort of in progress or that had just recently passed. So we'll review a few of those, talk about some new ones. We've got a sort of new topic. We don't often or always talk about issues with access or court access, but we've got an important one that we wanted to just make sure people are aware of. We're seeing more and more movement around privacy legislation, so we've added that as an agenda topic, and I imagine we'll continue to see this in future quarters. eVerify, we had one that sort of popped up on my radar, so I wanted to get it on your radar as well, and then an update on some FCRA litigation. And then drug testing, especially marijuana legalization legislation is fast and furious right now. Hundreds and hundreds and hundreds, literally, of bills that are making their way mostly through state legislatures. So we're going to talk about some. We're going to focus on the ones that have passed or recently passed, or again that we talked about last time, but maybe it was new or hot off the press, and there's some updates. So that's our plan. Hopefully, we'll have time for wrap up. I was telling Jeff this morning, it is crazy right now with things changing and things getting completed. So you know, I was all ready to go last night, and 4 new things came over. Hit my radar this morning. So do keep in mind things are changing rapidly. We are sort of in the middle of legislative session, so we are seeing things pass. So you know, something could happen today or tomorrow, and so this can become out of date quickly. But I wanted to just talk to you about the things that we do know about. So starting right off, and I just picked alphabetical order this time. Alabama recently passed their Redeemer Act. So this is a decriminalization effort coming out of Alabama. So this allows for some misdemeanors, certain nonviolent felonies to be eligible to be expunged. We're seeing this trend, and it varies a little bit in how it's implemented. In some cases, we'll have a process like as happened in Alabama, where the legislature says, you know, sort of lays out in the statute, here are those cases that are eligible to be expunged. And then it requires each individual that meets those qualifications to, you know, petition the court for the case to be expunged. In other cases, we're just seeing outright, especially around marijuana decriminalization, we're seeing outright decisions about where the statute says, you know, effective, you know, on, let's say July 1st, this marijuana possession is no longer illegal, and by statute, they're ordering the expungement of previous convictions. So Alabama a little bit different here, and this is got some very specific requirements. So for misdemeanors, convictions can be expunged where the probation or parole's been completed, where a certain amount of time has passed since the conviction. I think it's usually 3 years. And there's some exclusions, right? So it may not be available to somebody who's going to be operating a commercial vehicle. It's not allowed for a violent offense, which again, you wouldn't necessarily expect a violent offense to be a misdemeanor, but it does call that out, as well as sex offenses. And it is a judge decision. So they have a list of factors that they take into consideration around making the decision. On the felony side, I thought it was interesting that they were making some felonies available to be expunged, but once you start to dig in, basically in order for a felony conviction to be eligible for this expungement program, the individual has to have been pardoned, granted a certificate of pardon. So for convictions, felony convictions, much tougher process to get that expungement to happen. So that's Alabama. Waterloo. We talked about Waterloo, Iowa last quarter. They had passed a city ordinance. It was a ban the box ordinance, and it was applicable to public and private employers in the city of Waterloo with 15 or more employees. The city was then quickly sued by the Iowa Association of Business and Industry. They argued the ordinance is contrary to state law because there's a state statute that says a city can't adopt an ordinance that basically provides for terms or conditions of employment that meet or exceed some requirement of federal or state law. And so the argument was that this adoption of this ban the box ordinance was contrary to that state law. We had a decision just earlier this week. So Waterloo, Iowa employers, no, they affirmed in part and they nullified part of it. So basically they said, yes, the ordinance can apply to businesses more than 15 employees. Employers can't ask about applicants' criminal histories until they've extended the conditional job offer. But they made null the section that prohibited businesses from making the decision to hire or not hire solely based on the criminal record. So it's a little bit of a split decision there for Waterloo employers, a bit of relief for the employers around being able to make the decision based on the criminal conviction, but still applicable, and it preserves the timing aspect or the timing part of that ban the box law or ordinance. Illinois, this one, again, an update from the last time we talked. We did talk about it last time. It had been, I think, passed through the General Assembly, and it was waiting for signature from the governor. The governor did indeed sign that late March. It was effective upon signature. You might remember Illinois already had some ban the box limitations as part of their Human Rights Act. That prevented the employer from asking about criminal history on the employment application. With the update, they now are required, or it's now a civil rights violation for the employer to use a criminal conviction record in the employment decision unless there's a substantial relationship between that criminal record and the duties of the job, or where the records present an unreasonable risk to property or safety of individuals or to the general public. And so employers are required to consider, as they're determining whether there's a substantial relationship or an unreasonable risk, they're required to go through what looks to me a lot like EEOC or Illinois equal employment considerations around the length of time since the conviction, whether there's any other convictions, the nature and severity of the offense, the facts and circumstances surrounding the conviction, the age of the person at the time of the conviction, and any evidence of rehabilitation. So as you're reading that, if you're like me, you're thinking that sounds a lot like the EEOC guidance around doing an individualized assessment. And then kicker, Illinois I'm sure it was very well considered, but they had a requirement that if you are going to consider not hiring someone in Illinois based on your criminal conviction, you've gone through this analysis, you've done this individualized assessment, you also need to put in the notice to the applicant that you're considering not hiring them, an indication of the basis or the reason for that preliminary and then also final decision. So the reason, the basis that they're looking for is where there's a substantial relationship between the criminal record and the job, or where the records present or where the case represents an unreasonable risk. So the basis for your decision needs to also go into your letters. So if you are sending your own adverse action letters out to your candidates and you haven't yet inserted that step of adding information about that, make sure that you do that. There's also a requirement that you notify in that final adverse action that you notify them of their right to sue. And then also there's a 5-day waiting period that's in this Illinois statute. So 5 days is already sort of the minimum under the Fair Credit Reporting, the Federal Fair Credit Reporting Act. But this actually puts that waiting period in directly into the statute. So just a reminder on Illinois, that's been effective now since really right after the last session we did. But it's gotten important, especially from a documentation standpoint, adding that information to your adverse action notices, or if you decide not to put it in your adverse action notice, then it's a separate set of communications that need to go to your candidates. Louisiana, hot off the presses. Louisiana had passed fair chance legislation, and it was just passed last week. So it goes into effect here in August. Employers may not consider arrest records or charges that did not result in conviction. Most employers don't, right? Most employers are not looking at arrest-only cases. The statute so far is silent on pending cases. So that will be a question for Louisiana employers, whether they want to receive pending case information or whether they want that information excluded from their background screening report. But certainly arrests that were never adjudicated or that were actually dismissed, or where there was a finding of not guilty, that would be records that employers would want to exclude from their consideration. For other criminal history records, so for instance, for convictions, employers must also now do an individualized assessment of whether the criminal history has a direct and adverse relationship with the specific duties of the job. And then it gives some things to consider. So again, the nature and gravity of the offense, the time that's elapsed, the nature of the job sought. Those sound like green factors to me, right? Coming out of case law from the 70s, but most employers are familiar with those concepts. But again, here we've got a state that's actually legislating this requirement. So no longer just guidance from EEOC in these states where the individualized assessment process is now being legislated and is required by statute. The employer is required to provide a copy of the report that was relied upon for the decision upon request. Thought this was a super, I mean, I don't know where that comes from a statutory standpoint, because for employers are already providing the copy of the consumer report as part of the pre-adverse action process that's required under federal law. So most employers are already going to comply with this automatically and not wait for the consumer to make the request. And then just for those of you who super pay attention, this builds on it sort of sits beside actually the ban the box legislation in Louisiana that pre-existed. So that ban the box legislation had been around for a few years, but it applied only to state employment. And it required employers, it said employers couldn't ask about criminal records until after the interview. So for any of our listeners who are in state employment in Louisiana, don't forget you still have those ban the box legislation requirements, and then layer on this fair chance legislation. For non-state employers, this fair chance legislation that's new absolutely is intended to apply to private sector employers as well. A reminder about New York City. I put this one on here. It's been a while now since it was passed. I think we're coming up on 6 or 7 months, but it has an effective date here coming up in July. So just a reminder about employers in New York City. Applies to employers with at least 4 employees nationwide, at least one of them working in New York City. So interesting applicability question there. But you may recall, so this ordinance expanded the scope of the existing Fair Chance Act. And again, we're seeing attempts to put into statute what was previously perhaps just guidance from the EOC or from the state equal opportunity agency. So here in New York City, the individualized assessment and additional steps for withdrawing an offer required by current laws now also apply not just to convictions, which is what it was before, but to open and pending cases, criminal charges and accusations. So sort of just expanding that individualized assessment requirement that was already in place to not just convictions, but other non-conviction records that the employer might be considering. Have to specifically consider whether the applicant or employee was 25 years of age or younger at the time of the offense. There's additional communication and a waiting period. There's a special form in New York that New York City employers should be using. Also clarified that this ordinance applies not just pre-employment, but also to records or cases that are coming up during the employment. And employers cannot inquire into or make a hiring decision based on non-pending arrests. So thankfully here, the drafters were thinking about there's a difference between a pending case and an arrest that's never adjudicated. And so they were clear. They are saying arrests or criminal accusations, employers shouldn't be making inquiries in or making hiring decisions based on. Added to that, some special statuses, adjournments and contemplation of dismissal, youthful offender adjudications, and sealed offenses. So most employers probably already are not getting those sorts of records because they're not considered convictions in New York City. But those are sort of alternative adjudications that happened that do happen there. So just drawing your attention to that. And then also employers want to be really careful that they are not making decisions based on violations or non-criminal offenses. So infractions, things that do not rise to the level of being criminal in nature by statute, they're going to be excluding that. Philadelphia, another reminder. So again, we talked about this last quarter, but we had an effective date that happened since then. So just a reminder, they updated their fair criminal record screening standards. I've got effective in there twice, not sure why. But they, importantly here, they expanded the definition of an employee to be, I think, more broad. I think what happened here is there was an interpretation that employment meant only I-9 employee, right? And this is an attempt, I think, to clarify that the ordinance is intended to apply more broadly to any person employed or permitted to work at or for a private employer within the boundaries of the city as an independent contractor, as a transportation worker, as a rideshare driver, or as a gig economy worker. So trying to pull in the gig industry under the ordinance. Also made clear the way the ordinance was previously rolled out, that they, with the new update, they intended for it to apply not just to current employees, but also to applicants. Sorry, not just to applicants, but also to current employees. Expressly allows inquiry into pending cases under some circumstances and provides a private right of action. And then along with that, at the same time, there was an update to the ban on this credit screening exception. So if you are in Philadelphia and I feel like your employment or your employment practices are applicable there, these two bills are worth looking into and spending some time on. They're pretty specific, and the credit one is pretty specific as well. So kind of rounding out all of the activity happening with Ban the Box and Fair Chance, we do every year see a bill introduced federally. It ran out of time last year, and it was introduced really early this year by Democrats. So it looked like they were really going to try to take another run at the legislation. I think, you know, the idea here is the idea of this statute would be to tie funding for crime or law enforcement programs to states adopting ban the box legislation that would apply to private sector employers, not just public sector employers. So an interesting approach. Recall that in 2019, we did have the Fair Chance Act passed, but it applied only to federal employers or federal contractors. So this is an attempt to try to legislate on the federal level by pushing states towards creating their own legislation. I think it's unlikely to pass this year, frankly, even though Democrats have as you know, a tiny majority. Because of the type of bill that it is, passing this legislation would require 60 or more votes in the Senate, and I don't see that happening. So just an update, we get these every year. There's actually probably a couple of competing similar bills. This one was interesting just because it was tied to funding for law enforcement, which is an interesting approach, right? I think of ban the boxes should be in labor and employment or something like that. But they're trying something. I don't think it'll pass, but we'll keep an eye on it. And then moving sort of into some non-ban the box, a little bit of potluck here with other topics. We have an access issue that's going on in Michigan. We've been communicating with our clients about this, but just in case you're not getting regular communications from us, a little information about this. So Michigan courts have adopted a rule to redact personal identifiers from court records when those court records are made accessible to the public. Sounds like a lovely privacy initiative, I'm sure, you know, made with the best of intentions. But the problem, of course, is this is, you know, the use of personal identifiers, like especially date of birth, are between name and date of birth, the main identifiers that employers use to find criminal records at state courts, right? So the problem that will result with redacting all of dates of birth from public records in these courts is that our ability to search and find records and exclude records based on a non-match on date of birth especially could be severely impacted. So we've been doing a ton of lobbying. The Professional Background Screeners Association has really been leading a lobbying effort. And so far, the Michigan courts are not backing away from their time frame, at least, set to go into effect July 1st, 2021. We saw a few courts try to implement the policy a little bit early. Mostly they backed off because there is so much controversy. The impact for employers, of course, will be that there's likely to be delays, right? The proposed solution from the courts are, in the event that the background screening company needs a record to be matched by date of birth, that we would provide them a paper version of an authorization form from the candidate. And then if they had that authorization form, they would then either provide the identifier or match or no match the record. You can imagine the sort of backlog that could create with public records researchers going into courts all day, every day across the state. So we are working, lobbying against this effort. PBSA is lobbying against the effort. We think that courts will, some of them will take a hardline approach and say, nope, sorry, you're not getting a date of birth match no matter what, even if we have an authorization form from you, try to use some other identifier. We expect some will, just follow the letter of the rule and say, give us an authorization form and we'll put it in it. We'll get it to you as soon as we can. And we expect some courts will just say what rule and continue to provide records. So we'll have to see how this develops. In the meantime, here at Orange Tree, we are looking at, what are alternatives? Where are other places that we could possibly get records? Where are other places that we could possibly confirm identifiers? They're sort of ready and waiting to go, but we're just still hopeful that the courts will make a different decision before that July 1st deadline. So if you're interested in helping lobby with that, our customer care team, oops, sorry, I'm sure that was a horrible noise. Our customer care team can get you a template or get you some contacts to send letters to, or you can check on the pbsa.org. It's the pbsa.org website. I think they have information about it right on the homepage. So more to come on that. I'm sure we'll have an update actually probably by next week. Next topic, Michigan was really the only access issue that we had to report on, but a new topic we also don't often have things to report about, and suddenly we have 2 states that have now adopted their own privacy protection acts. Data privacy or data protection acts. So Virginia, we did talk about last time. It was, again, I believe it had been passed, but not yet signed by the governor. It's now subsequently been signed. This is the 2nd state to pass state privacy legislation. After California was the 1st. We do have some time here before it becomes effective, so January 1, 2023. And there's a definition in the statute of, to what sort of businesses the Consumer Data Protection Act will apply to. It's based on the number of records that you have or that you're storing and or your gross revenue. And so look at that calculation carefully. The good news for employers, it does appear that employment data is excluded specifically from the statute's applicability, and also excluded is information covered by the Federal Fair Credit Reporting Act. So good news for employers there. Generally, the statute requires online privacy protection standards for controllers and processors, gives consumers rights to access, correct, delete data about themselves, obtain a copy of their personal data, and opt out of processing for targeted advertising. No private right of action in Virginia, which is an interesting approach. So that means regulatory compliance as opposed to individual private right of action, which again, I think is good news for most businesses. And then from an employer standpoint, I think good news in the specific exclusion of employment data and FCRA covered information. Also hot off the press, I literally got this one this morning. Colorado passed by their state assembly yesterday This one is pending signature from the governor, but no reason to think it's not going to happen. This is the Colorado Privacy Act, and so they become the third state to pass privacy legislation after California and Virginia. We've got a little more than a year here before we have an effective date, and applicable again, based mostly on either the number of consumer records that you process or store, and then potentially, just process and store, and based on the residency of the Colorado consumer. Again, good news for employers. It excludes personal data collected by a consumer reporting agency and employment records. So good news there. Obviously, for companies, regardless of them being an employer or not, may have still a need to comply with the statute based on the applicability of the statute. But it outlines privacy protections and standards for collectors and processors. So very similar to Virginia, and gives consumers the right to access, correct, delete, obtain, copy, or opt out of processing for targeted advertising. And again, in Colorado, no private right of action. So good news for employers there. You can see, though, why it becomes more and more important potentially for some action here at the federal level. We did have the Workforce Justice Act. It was an amendment to the Omnibus Crime Control and Safe Streets Act of 1968, introduced this year. So in this current Congress would tie I think I have the wrong information here on this slide, so I'll fix up this slide. But I also don't expect that we'll see federal privacy legislation pass this year. I just think so much time was taken up with COVID relief and getting legislation passed there that I just don't foresee I don't foresee having enough oomph to get this one through. Maybe next year, right? Maybe when there's not this huge, hopefully COVID distraction next year, they'll get something passed. I think that it would be helpful for employers to have a single standard to pass. So the question will be, will the federal statute that gets passed, when it does get passed, if it does get passed, include preemption? So employers, I think, would be looking for preemption so that it would preempt any state laws that have passed and that continue to pass statutes. And then also that it would, whether or not it would exclude or include that private right of action. So those two, I think, are the sticking points here on getting that federal legislation passed for privacy. We'll see how it goes. I just don't think it'll happen this year. We'll keep an eye on it. And then also at the federal level, just a reminder, we talked a little bit about the Ramirez v. Transunion case that made its way up to the Supreme Court this year. That was scheduled to be heard by the Supreme Court in March, and that did happen. So the issue in this case is whether Article 3 standing or federal civil rules of procedure permit a class to be certified where the majority of the class suffered no actual harm. So the facts here were the background screening company reported an unmatched OFAC record about this plaintiff that allegedly that caused the plaintiff to have his credit application denied. And so the case came where he was the named plaintiff of a class of 8,000 consumers. And so there was certainly an issue and potentially damage for this named class member. But the question is, did everyone else in that class suffer same or similar damages or any damages, and if they didn't, was it correct for that class to be certified? So that is the question that was argued before the Supreme Court. I didn't hear anything that made me, want to put any money on which way the court would go. But there is a decision expected here before they adjourn, before the 4th of July holiday. So we will watch for that and give you an update next time on that as well. We just think the decision's likely to have a significant impact on FCRA class action suits. So we are hopeful about the outcome of that case. And then just one more topic. We don't spend a lot of time usually here, but I wanted to just bring it to everyone's attention, a reminder. Last year, almost a year ago now, Florida had a bill that passed, signed by the governor, was effective January 1st, 2021. And it mandated use of eVerify for government employers, contractors, and certain private employers. And then importantly, the piece of this that I think may have flown under the radar for many private employers were given the option to participate in eVerify if they chose to, but if they do not choose to, this state statute requires private employers in Florida to maintain copies of the documents that were used to complete the I-9 form for 3 years. So significant issue there in that federal law, the I-9 form instructions themselves don't require employers to maintain copies. The employer chooses whether they're going to maintain copies or not, and then is expected to always follow that policy. And then there's specific retention requirements for I-9 forms under federal law. And this Florida law requires retention of those copies for 3 years. Just wanted to get that on radars for those of you that are employers in Florida. I think it kind of flew under for private employers, especially since they were mostly exempted from the statute. I'm just a little concerned that some employers may have missed that part about requiring the documentation. Okay, so moving on into drug testing. As I mentioned at the beginning of our session, so many bills related to drug testing. Vast majority of them are related to marijuana, but lots of variability, right? Also, we're seeing, things related to specific industries or specific types of jobs, like bus drivers or testing for bus drivers. We're seeing legislation related to fraudulent drug test activities, making that criminal, right? So some of that legislation going on. We think for employers, probably the most interesting topics to talk about here are medical marijuana and recreational marijuana, and we're focusing today here on the laws that have recently passed or that passed since the last time we met. So far in 2021, Alabama had a medical marijuana law that passed, and then for recreational marijuana, we're tracking New Jersey, New York, Virginia, New Mexico, Connecticut. And some of those are really just hot off the press. So we also had a few updates to existing marijuana laws. So we'll talk about those as well. Alabama, their medical marijuana law was signed into law in May by the governor. It legalizes medical marijuana for adults and minors with certain conditions, requires a doctor's recommendation. The program calls for an implementation of entire regulatory scheme, right? So determination of how it can be produced in the state, who can sell. Sorry, we're talking about medical marijuana. So medical marijuana cards, confirmation of what qualifying conditions are. So Effective now, likely the program actually may not be available until mid next year. There's a few parts of the statute that address things that employers are concerned about. It says employers are still not required to accommodate use and can refuse to hire even if used legally. So very employer-friendly legislation in Alabama. Employers can still create a drug-free testing policy that excludes medical marijuana use or requires notification of use. So an interesting approach in Alabama. They sort of, as we've seen very often when the state passes a medical marijuana program, within a few years, they're also passing recreational marijuana programs. The legislation is seems to imply that that's not the intention here, that they intend to stop with medical marijuana. I think that's probably unlikely, but it was an interesting approach. Connecticut signed into law just earlier this week, legalizes the use and cultivation of recreational marijuana for people over the age of 21. This one includes expungement of many past convictions for possession, so automatic expungement. So we'll start to just see those cases disappear from public records. The program or the statute effective July 1st, but again, program probably won't be available until mid 2022. Employers can maintain a drug-free workplace policy and implement policies prohibiting possession, use, or consumption by an employee, but there are some exceptions. Policies have to be in writing and made available to candidates' employees, specifically not friendly to employers, can't discharge, refuse to hire, or otherwise take adverse employment against an employee or prospective employee based on their use outside of the workplace. Before the employee or prospective employee became employed. So that, the question there is pre-employment drug testing for marijuana. Unless the employer doing so would cause them to violate a federal contract or lose federal funding. So some help there for employers that are, that have safety sensitive positions. Obviously, the state laws around marijuana can't or are not applicable to DOT regulated positions, safety sensitive positions. And in general, reiterating, employers can't discharge an employee for use outside of the workplace. And then just a reminder, Connecticut already has some restrictions on testing of current employees. So you want to be careful about implementing that along with this recreational marijuana statute. Mississippi, this was an update from last time. So last time we talked about the fact that the voter initiative passed. It was a medical marijuana law, and it covered debilitating conditions, was to be implemented by July 1st. It didn't have any guidance for employers about rules or regulations to be implemented. And in May, the Michigan Supreme Court held that the initiative process was unconstitutional. Very interesting procedural issue here with how they did their voter initiative. And it was it's technical. It's very likely, actually, I suspect Mississippi legislators are likely to take this up and may pass legislation about it yet this session, but we'll see. We will see what happens there. But this is interesting, right? We don't see this happen all that often, except there's another one coming up on the list. We'll talk about that in a minute. Montana, just a reminder, because this one comes in effect here later in the year, recreational marijuana law, Initiative 118. It creates a recreational marijuana marketplace and opens that marketplace to individuals 21 years of age and older. Employers in Montana are not required to permit or accommodate in workplace or on work property use or possession, and may take disciplinary or adverse action for violations of their policy. Can deny employment based on violation of that policy, both pre-employment and a positive drug test, assuming that's outlined in your policy, could still be the subject of adverse action, and can still, of course, discipline employees that are working while intoxicated. New Jersey, really the only thing that's happened here is an update to the effective date. So it was a little unclear when the effective date would be when it was originally passed, but this was also a voter initiative. That subsequent legislation to implement the program did pass, and so now effective here August 21st, 2021, removes marijuana as a Schedule I drug and legalizes use for adults over 21. It explicitly does provide protections for employees who engage in off-work marijuana use from adverse employment actions. So a tough one for employers. It limits the employer's ability to act on the basis of a positive marijuana test after employment has started. So be careful of when you're drug testing current employees. It allows the employer to maintain a drug and alcohol-free workplace, not required to accommodate use, consumption, being under the influence, possession, transfer, display, transportation, sale, growth in the workplace. They were thorough, at least. And employers can have policies prohibiting use or intoxication during work hours. Created a whole new concept of something called an impairment recognition expert. Presumably, this individual or somebody with this certification would be able to recognize impairment. The Cannabis Registry Regulatory Commission is working in conjunction with the Police Training Commission to pull together a training program. We'll see if they're able to do that before the effective date of the statute. Otherwise, employers are going to have to be thinking about how to do drug testing or how to recognize impairment or use without some sort of certified employee to help them with that requirement of having an impairment recognition expert. Tough one in New Jersey for employers. New Mexico, we talked about this one last year as well. Last quarter as well. Was signed in April. We're talking about it today just because effective date here is coming up. This is recreational marijuana law. It legalizes it for individuals 21 and older. It establishes limits on, how much can be in possession, how much can, it says that recreational marijuana must be smoked, vaporized, or ingested in a designated cannabis consumption area. So it doesn't prevent or infringe on the rights of employers to adopt or implement their zero tolerance policy. So an interesting approach in New Mexico. Unfortunately, applicants not specifically included in the language of the statute. So it'll be interesting to see whether they were intended to be, so whether pre-employment testing was intended to be included in that language. Adverse action is permitted for possession or use in the workplace during work hours. Employers must use care not to restrict the rights of medical marijuana participants. And then here's another example. At the same time, we had a bill go through in New Mexico allowing expungement of certain medical or marijuana related criminal offenses that become legal on June 29, 2021. So June 29, 2021, what previously were offenses are no longer criminal offenses, and they're going to go in and automatically expunge records that fall within the definition of those statutes that are no longer criminal. So interesting approach. We'll see if the courts can get it done. New York. So this is the state of New York. They passed a couple of bills in March, got signed by the governor at the end of March with immediate effect. Legalizes recreational marijuana law and expands the medical cannabis program, and legalizes possession, purchase, use for individuals 21 and older. Also specifies, again, how much you can have or use. And also, I think the New York statute really focuses on creating a market, right? So licensed sales are scheduled to be allowed in early 2022, but residents are immediately permitted to grow plants in their home and smoke marijuana basically anywhere smoking tobacco is currently allowed. So interesting approach. Employers, again, can continue to have policies regarding use in the workplace, but can't take adverse action based on the use of a legal product or activities outside of work hours. So again, have a care. The statute includes the creation of the Office of Cannabis Management to be governed by a new Cannabis Control Board. And that will be the agency that's developing and implementing the regulatory scheme for licensure, cultivation, production, taxation, sale, etc. So South Dakota, this is the one I previewed a little bit. So they passed a voter initiative. We talked about it last quarter. It was a medical and recreational marijuana law, and that actually ended up being the issue that was problematic. It was ruled unconstitutional because the voter initiative statute requires that the topic be limited to a single topic. And here, since it was medical and recreational marijuana, there was a question about whether that's more than one topic. It was ruled unconstitutional by the lower court. It's been appealed to the South Dakota Supreme Court. I'm expecting that we'll get a decision any day now. Virginia. So Virginia had House bill that was signed into law by the governor in April. Effective date in July, coming up here. Another recreational marijuana law, legalized marijuana use for adults 21 and older. Employers are permitted to prohibit presence of marijuana on the premises, also within the boundaries of the law to fire an employee who is impaired at work as a result of marijuana use. Not too much help there for employers, right? We'll see how that one develops. The law also, there was also a medical marijuana bill related to lawful use of cannabis oil. So employers will want to be looking at the medical marijuana law as well. Employers are still permitted to take adverse employment action if the employee's performance is impaired by the use. And they can also prohibit possession of cannabis oil during work hours. And employers that are not required to allow use of medical marijuana or cannabis oil where that would violate federal law or cause them to lose a federal contract or federal funding, or where and then there is also, they don't have to hire or retain applicants in the defense industry where there's a marijuana positive. So a few protections for employers there in Virginia, but again, a tough spot. And that is my last slide. It's 12:59. Jeffa Renew was